Welcome to this podcast on some key aspects of the English law of tort. We will discuss liability arising from the use of premises and occupiers' liability. We will also look at nuisance and the rule in Rylands and Fletcher before delving into the crucial contemporary topic of privacy. We will address elements of the law as they relate to undergraduate law students and those taking the solicitor's qualifying examination, the SQE. This podcast was prepared by Dr. Yannis.glinavos and is narrated by an AI voice. If you would like to know more about how this podcast was produced, get in touch with Dr. Yannis. Let's get started by trying to get a clear understanding of the legal distinctions between claims based on damage to property and those arising from defects in property. We do this to enable you to evaluate the so-called complex structure approach and analyze the leading authorities in this area, including D&F Estates versus Church Commissioners, 1989, Anns versus Merton, 1978, and Murphy versus Brentwood, 1990. Additionally, you should understand the current position on preventative expenditure aimed at avoiding damage to persons or property. Introduction. Physical damage to property represents a form of harm for which tort law typically provides compensation. Many cases in this domain arise when claimants either incur expenditure or fail to realize a profit due to a defect in a product, land, or building they have acquired. Today's discussion will examine claims regarding damage to property, highlighting the critical distinction between claims based on such damage and claims based on a defect in the property itself, the latter being a concern of contract law rather than tort law. Economic loss. Acquiring defective property. Physical damage to property is, as a general rule, compensable in tort, provided other recovery rules are satisfied. An example of this is found in the law of nuisance, which compensates for so-called amenity damage, instances where enjoyment of property is diminished, such as from unpleasant smells emanating from a neighboring factory. When claims arise from physical damage, they fall under the tort of negligence, provided the damage stems from more than just a defect in the property. Claims concerning defective property are addressed through contract law, as tort law does not recognize a duty of care for defects unless the defect causes damage to other property or a person. A key line of cases in this area involves property, such as homes or flats, that display signs of physical deterioration, requiring claimants to either repair or sell at a reduced value. Landmark cases in this area include D&F Estates versus Church Commissioners, 1989, and Murphy versus Brentwood, 1990, both of which clarified the boundaries of liability. Defects and damage. In cases of defective products, tort law does not typically recognize economic loss, which is primarily recoverable through contract. However, the seminal case of Anns versus Merton LBC, 1978, challenged this principle. In Anns, a block of flats developed cracks due to shallow foundations, despite the local council's prior approval of the building plans. Lord Wilberforce ruled that the repair costs to restore the dwelling to a safe condition were compensable as material physical damage. This marked a significant expansion of the duty of care in negligence. Subsequent cases, however, rolled back the precedent set in Anns. In D&F Estates versus Church Commissioners, the House of Lords ruled that a defective product, in this case, negligently applied plaster, did not give rise to liability in negligence unless it caused damage to other property or injury. This judgment clarified that the discovery of a defect, absent resulting damage, constitutes pure economic loss, which is outside the scope of tort. This position was reinforced in Murphy versus Brentwood, D.C., 1990, where the House of Lords ruled that a local authority was not liable for approving defective building plans that led to subsidence in a house's foundations. The damage was confined to the property itself, making it a case of pure economic loss. Lord Bridge emphasized that allowing recovery for defects alone would blur the boundaries between tort and contract law, relegating such claims to the latter domain. The complex structure theory emerged as a potential avenue for claimants. This theory posits that a building may be viewed as a series of interconnected components, allowing damage to one part of the structure to be treated as harm to other property. For example, a faulty boiler exploding and damaging the rest of a house could be recoverable. However, in Murphy, the House of Lords dismissed this theory as artificial and impractical, particularly when applied to integrated structures like houses. Lord Jauncey argued that a house, built as a single unit, cannot realistically be divided into separate components for the purpose of liability. The current position, the law now firmly classifies preventative expenditure to avoid damage to persons or property as economic loss, which is not recoverable in tort. A clear distinction exists between defective property causing harm to people or other property, where damages are recoverable, and property that is merely defective and worth less than it should be, where damages are not. The Defective Premises Act 1972 supplements this framework by imposing a statutory duty on builders and related professionals to ensure their work is conducted professionally, with proper materials, and results in a dwelling fit for habitation upon completion. This statute underscores the boundary between tort and contract law by delineating specific duties owed by professionals to ensure fitness for purpose. Conclusion. In understanding economic loss and defective property claims, it is essential to recognize the nuanced distinctions articulated in the leading cases. While Yannis initially expanded the scope of liability, subsequent rulings in D&F Estates and Murphy have reasserted the primacy of contract law in addressing pure economic loss. This framework reinforces the principle that tort law primarily protects against harm to persons and other property, leaving disputes over defective property to contractual remedies. We now move on to explain which entrants into private premises are lawful visitors and which are not, define who is to be treated as an occupier of premises. This is aimed to provide you with knowledge of the duty of care owed by occupiers to lawful visitors under the Occupiers Liability Act 1957, and describe and explain the nature and extent of the occupier's duty to trespassers under the Occupiers Liability Act 1984. Introduction. The duty owed by occupiers of premises to those in or on the premises has long been recognized in common law. However, the common law duty has been replaced by statutory negligence-type duties under the Occupiers Liability Acts 1957 and 1984. These acts establish the framework for liability based on the status of the entrant and the circumstances of the case. Background. By 1957, the common law on occupiers' liability was seen as unsatisfactory due to its rigidity and complexity, with different duties owed to different classes of entrants. The Occupiers Liability Act 1957 sought to address this by codifying the duties owed to lawful visitors. Meanwhile, a limited duty was owed to trespassers, which was later formalized under the Occupiers Liability Act 1984. The acts replaced the common law rules where they apply, meaning no alternative common law action in negligence can be brought for claims falling within their scope. The acts deal only with liability for harm occurring on the premises, not harm caused to those outside the premises. Occupiers Liability Act 1957. This act applies primarily to lawful visitors and defines the occupier's duty as the common duty of care. The scope of the act includes injuries arising from the state of the premises, but activities on the premises are usually governed by common law negligence. For instance, in Slater v. Claycross Co., 1956, Lord Denning emphasized the general duty of care owed by landowners for activities occurring on their land. The Act's coverage extends to fixed and movable structures, as seen in Wheeler v. Copas, 1981, where a ladder was held to be within the definition of premises. The question of who qualifies as an occupier depends on control rather than ownership, as illustrated in Wheat v. E. Lacken and Company Limited, 1966, where both the owners and the manager of a pub were deemed occupiers due to shared control of the premises. Lawful visitors include those with explicit or implied permission to enter, such as invitees, licensees, and individuals exercising statutory rights. The nature of permission can be limited by time or area, and breaches of these limits may change a lawful visitor's status to that of a trespasser. For example, Scruton L.J.'s statement in the Calgarth, 1927, clarified that entry must align with the purpose for which permission was granted. The duty owed under the Act requires the occupier to take reasonable care to ensure the visitor's safety. This flexible duty depends on the circumstances, as demonstrated in Cole v. Davis-Gilbert, 2007, where the court emphasized the need for reasonable standards without imposing overly burdensome duties. Similarly, in White Lion Hotel v. James, 2021, the Court of Appeal confirmed liability for failing to address a known hazard, though contributory negligence reduced the claimant's damages. Children are owed a higher duty under the Act, as they may be less aware of risks. In Glasgow Corporation v. Taylor, 1922, The defendants were held liable for failing to fence off poisonous berries that attracted children. However, responsibility may also fall on parents, as seen in Phipps v. Rochester Corporation, 1955, where the court placed primary responsibility on parents for supervising young children. Trade visitors are expected to appreciate and guard against risks inherent to their profession. In Rolls v. Nathan, 1963, chimney sweeps who disregarded warnings about carbon monoxide risks were deemed responsible for their injuries, absolving the occupier of liability. Warnings in independent contractors also play a role in discharging the occupier's duty. A warning must adequately inform visitors of the danger, as seen in English Heritage v. Taylor, 2016. For independent contractors, the occupier must select competent professionals and take reasonable steps to ensure the work is properly done, as established in Haseldean v. Daw, 1941, and Bottomley v. Todmorden Cricket Club, 2003. Occupiers Liability Act 1984. The 1984 Act applies to unlawful visitors, including trespassers, and imposes a duty to act with common humanity. This duty arises only if three conditions are met. The occupier is aware of the danger, knows or should know that the trespasser may encounter it, and the risk is one against which protection is reasonably expected. The duty is to take reasonable care to prevent injury, but it is less stringent than the duty owed to lawful visitors. In Ratcliffe v. McConnell, 1999, the court upheld the principle of volenti non fit injuria, finding no duty owed to a trespasser who willingly accepted the risks of diving into a closed swimming pool. Similarly, in Tomlinson v. Congleton Borough Council, 2003, the House of Lords rejected a claim by a trespasser who suffered injuries after diving into a prohibited lake, citing policy reasons against imposing excessive burdens on public bodies. In summary, the duties under the Occupiers Liability Acts of 1957 and 1984 reflect a balance between ensuring safety and recognizing personal responsibility. Lawful visitors are afforded greater protection, while trespassers receive a limited duty based on the circumstances of their entry and the nature of the danger encountered. We will now explain the difference between various forms of nuisance and, when each form is applicable, apply the rule relating to the tort of private nuisance, and, in particular, identify who can sue, when a court is likely to find liability, what defenses exist, and what remedies are available. You should also be able to outline the basic rules of the tort of public nuisance, understand the potential for overlap between nuisance and the torts of Rylands v. Fletcher and negligence, and identify the influence of the Human Rights Act 1998 on this area of tort law. Introduction. There are two common law torts with the word nuisance in their name, each distinct in application and purpose. Private nuisance addresses indirect interferences affecting the use and enjoyment of land, such as noise, smells, and fumes. Public nuisance, on the other hand, is broader in scope, serving as both a tort and a crime, typically concerned with activities affecting the public's reasonable comfort and convenience. While the Police, Crime, Sentencing and Courts Act 2022 replaced the common law offense of public nuisance with a statutory offense, it left the tort of public nuisance intact for individual claimants experiencing special damage. The different forms of nuisance. Private nuisance arises when there is an unlawful interference with an individual's use or enjoyment of land, or a right connected to it. Public nuisance, in contrast, pertains to disturbances materially affecting the comfort and convenience of a class of individuals. The Environmental Protection Act 1990 Part 3 governs statutory nuisances, which fall outside the scope of this discussion. Private nuisance. Private nuisance encompasses three main types of interference: physical damage to land, substantial interference with the enjoyment of land, and encroachment by natural elements, such as overhanging branches. These interferences must significantly affect the claimant's use and enjoyment of land, as illustrated in Davey v. Harrow Corporation, 1958, where tree roots caused structural damage to a neighboring property. Who can sue? Only individuals with proprietary rights or exclusive possession can sue for private nuisance. In Hunter v. Canary Wharf Limited, 1997, the House of Lords confirmed that a proprietary interest is essential, overturning earlier decisions that allowed non-property owners to bring claims. However, questions have been raised about the exclusion of family members under Article 8 of the European Convention on Human Rights. What constitutes a nuisance? Lord Wright's definition in Sedley Denfield v. O'Callaghan, 1940, emphasizes balancing the defendant's right to use their land and the claimant's right to quiet enjoyment. Reasonableness is the key criterion, influenced by factors such as locality, duration, frequency, and malice. For instance, in Sturgis v. Bridgman, 1879, Thesiger L.J. noted that what constitutes a nuisance depends on the character of the neighborhood. Factors determining reasonable use. The courts weigh several considerations, including physical damage, the nature of the locality, and the utility of the defendant's conduct. For example, in Miller v. Jackson, 1977, the Court of Appeal balanced the social value of cricket against the plaintiff's right to quiet enjoyment, ultimately awarding damages instead of an injunction. Abnormal sensitivity, as demonstrated in Robinson v. Kilvert, 1889, and malice, as in Christie v. Davey, 1893, are also relevant factors. Who could be sued? Potential defendants include the creator of the nuisance, their employer, or the occupier of the land who adopts or continues the nuisance. In Sedley Denfield, the defendant was liable for a nuisance created by a trespassing local authority because they adopted the defective drainage system. Defenses. Defenses specific to nuisance include statutory authority, prescription, and the unforeseeable act of a stranger. Statutory authority applies when the nuisance is an inevitable consequence of activities authorized by law, as seen in Allen v. Gulf Oil Refining Limited, 1981. Prescription offers a defense if the nuisance has continued for over 20 years. Ineffective defenses include arguments such as coming to the nuisance or social utility, as reaffirmed in Coventry v. Lawrence, 2014. Remedies. Claimants may seek injunctions, abatement, or damages. Injunctions, though discretionary, are the primary remedy for ongoing nuisances. The Supreme Court in Coventry v. Lawrence reviewed the criteria for awarding damages in lieu of an injunction, emphasizing flexibility and public interest. Damages in private nuisance typically compensate for the diminution in land value or loss of enjoyment, as clarified in Hunter v. Canary Wharf. Public nuisance allows for recovery of damages related to personal injury and consequential economic loss, as in Tate and Lyle Industries Limited v. Greater London Council, 1983. Public nuisance. Public nuisance involves interferences affecting a class of individuals. Claims require proof of special damage, such as personal injury or economic loss exceeding that suffered by the public at large. In Tate and Lyle, the court awarded damages for the cost of dredging caused by excessive silting in the River Thames. Where special damage cannot be proved, claims must be brought in the name of the Attorney General or under statutory provisions. The influence of the Human Rights Act, 1998. Article 8 of the European Convention on Human Rights has introduced new dimensions to nuisance law. In Dennis v. Ministry of Defense, 2003, noise from military aircraft breached Article 8 rights, but damages were awarded instead of an injunction due to public interest. Similarly, in Marsick v. Thames Water Utilities, 2003, the courts limited the impact of Article 8 in cases involving statutory duties. Conclusion. The law of nuisance balances competing interests in the use and enjoyment of land. Private nuisance focuses on protecting property rights, while public nuisance addresses broader societal harms. Remedies range from injunctions to damages, with the courts carefully considering factors such as locality, reasonableness, and public interest. Understanding these principles is essential for navigating this nuanced area of tort law. We now move on to explain the nature of the rule in Rylands v. Fletcher and its relationship with other torts, analyze when a claim under Rylands v. Fletcher is likely to arise, identify who can sue and be sued under the rule, explain the available defenses, and understand the remedies. Introduction. The rule in Rylands v. Fletcher, 1865, LR 1X 265 is a strict liability doctrine protecting landowners from damage caused by isolated escapes of dangerous substances or items. Unlike private nuisance, Rylands v. Fletcher does not require a continuous activity. It also differs from negligence as it does not demand proof of a duty of care or its breach. Despite its historical importance, the tort's practical application has diminished due to the growth of nuisance, negligence, and statutory liability. Key principles of Rylands v. Fletcher. The foundational case involved the flooding of a coal mine due to the negligent construction of a reservoir. The principle, as articulated by Blackburn J., states, "The person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and, if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape." To establish liability under Rylands v. Fletcher, 4 elements must be proven. 1. Non-natural use of land. The use must be extraordinary and unusual, not ordinary or for general community benefit, as highlighted in Rickards v. Lothian, 1913. 2. Bringing and keeping a dangerous thing. The defendant must bring onto their land something likely to cause harm if it escapes. 3. Escape. The dangerous item or substance must leave the defendant's land, as emphasized in Reed v. J. Lyons and Company Limited, 1947. 4. Foreseeable damage. The damage caused must be a foreseeable result of the escape, clarified in Cambridge Water County v. Eastern Counties Leather, 1994. Land use and foreseeability. Non-natural use. This requirement has been pivotal in limiting the scope of Rylands v. Fletcher. The House of Lords in Transco v. Stockport MBC, 2003, underscored that strict liability is confined to extraordinary or unusual uses of land. Routine activities, such as supplying water to residential properties, do not satisfy this criterion. Foreseeable loss. The decision in Cambridge Water reaffirmed that liability under Rylands v. Fletcher requires foreseeability of the type of damage caused by the escape, aligning it with principles of nuisance. Who can sue? Only individuals with proprietary rights in land may sue under Rylands v. Fletcher, as confirmed in Transco. This aligns the tort with private nuisance. Earlier cases permitting claims without proprietary rights, such as Schiffman v. Order of the Hospital of St. John of Jerusalem, 1936, have been largely disregarded. Defenses. Several defenses exist to claims under Rylands v. Fletcher. 1. Act of a stranger. If the escape is caused by a third party's unforeseeable actions, the defendant is not liable, as in Rickards v. Lothian, 1913. 2. Act of God. Natural events that could not have been anticipated or guarded against, such as unprecedented weather, may absolve liability. However, this defense is rarely accepted, as seen in Greenock Corp v. Caledonian Railway, 1917. 3. Statutory authority. Activities authorized by statute may provide a defense if the nuisance is an inevitable consequence. 4. Consent. If the claimant has consented to the risk of escape, liability may be negated. For example, tenants benefiting from a shared water supply may implicitly consent to risks associated with it. Damages and remedies. Limitations. Damages under Rylands v. Fletcher are restricted to proprietary losses. Claims for personal injury are excluded, as clarified in Hunter v. Canary Wharf, 1997, and affirmed in Transco. Remedies. The primary remedy is compensation for the damage caused by the escape. Injunctive relief is not typically associated with Rylands v. Fletcher, given its focus on isolated incidents. Case law highlights. Cambridge Water County v. Eastern Counties Leather. This case established that foreseeability of harm is a prerequisite for liability. It also emphasized that industrial use of chemicals constitutes non-natural use of land. Transco v. Stockport MBC. The House of Lords confined Rylands v. Fletcher to exceptional circumstances involving extraordinary use of land and exceptionally high risks to neighboring properties. The case reinforced the tort's alignment with private nuisance principles. Conclusion. The rule in Rylands v. Fletcher serves as a specialized subset of private nuisance, addressing liability for isolated escapes of dangerous items. Its restrictive application reflects judicial caution in extending strict liability and its interplay with other torts such as nuisance and negligence. Understanding its requirements, defenses, and limitations is crucial for evaluating claims under this doctrine. The guiding principles from Cambridge Water and Transco provide a clear framework for navigating this nuanced area of tort law. Understanding the tort of privacy in English law. We finished today's podcast by diving into the fascinating evolution of privacy law in England. By the end of this discussion, you'll attain an understanding of some key elements, including the history of privacy protection in English law, the current legal approaches to privacy, how courts now recognize the tort of misuse of private information as a distinct cause of action, and the impact of the Human Rights Act 1998 on privacy law. Privacy law, as we know it today, is a relatively new area in the United Kingdom, but its development has been swift. Two pivotal events propelled this evolution: the enactment of the Human Rights Act 1998 and the increasingly invasive behavior of the tabloid press, amplified by modern technological advancements. Unlike defamation, which addresses false statements, privacy law protects private information, even when it is true. It has found particular relevance in high-profile cases involving politicians, celebrities, and members of the royal family. The foundation of modern privacy law rests on the European Convention on Human Rights, ECHR, and the Human Rights Act 1998. Article 8 of the ECHR guarantees the right to respect for private and family life, while Article N protects the right to freedom of expression. These two rights often conflict, requiring courts to carefully balance the interests of privacy with the public's right to know. One of the earliest cases to spotlight privacy concerns was Kay v. Robertson in 1991. This case revealed a glaring gap in English law at the time. Gordon Kay, a British television actor, was recovering in a hospital after a severe accident when journalists entered his room uninvited to interview him. The court granted an interim injunction to prevent publication, but the judgment underscored the absence of a statutory right to privacy, prompting calls for legislative reform. The evolution of a privacy tort has primarily revolved around two legal doctrines. First, the breach of confidence, originally tied to confidential relationships, has expanded to cover private information. Cases such as Prince Albert v. Strange and HRH Prince of Wales v. Associated Newspapers illustrate this development. Second, the tort of misuse of private information emerged as a distinct cause of action in the landmark case of Campbell v. Mirror Group Newspapers in 2004. Naomi Campbell's case established a standard for balancing privacy and freedom of expression, introducing the concept of a reasonable expectation of privacy. Modern case law continues to refine these principles. In Mosley v. News Group Newspapers in 2008, Max Mosley, then chairman of Formula One, was awarded substantial damages after a tabloid published intimate details about his private life. The court recognized his reasonable expectation of privacy, emphasizing that the publication lacked any legitimate public interest. Similarly, in Murray v. Express Newspapers, the Court of Appeal upheld the privacy rights of J.K. Rowling's young son, emphasizing that children deserve heightened protection from media intrusion. A more recent and significant case is Sir Cliff Richard v. BBC in 2018. Here, the BBC broadcast a live police raid on Sir Cliff's home, which was unrelated to any charges. The High Court found that the coverage violated his privacy, awarding him considerable damages for the distress caused. The case reaffirmed that individuals under investigation have a reasonable expectation of privacy. When privacy is breached, claimants typically seek two forms of remedies: damages and injunctions. Damages aim to compensate for distress or reputational harm, as seen in Mosley and Richard. Injunctions, on the other hand, are often sought to prevent further publication of private information. Given the urgency of many privacy cases, interim injunctions are a powerful but controversial tool, as they can restrict freedom of expression before a full trial. To summarize, the trajectory of privacy law in the UK highlights its adaptability to the challenges posed by modern society. The recognition of misuse of private information as a tort underscores the legal system's responsiveness to evolving societal needs. As technology and media continue to advance, the principles established in these cases will remain crucial in navigating the delicate balance between individual rights and public interest. Before we wrap up, here are a few reflective questions for you to consider. How do you perceive the balance between privacy and freedom of expression? Should public figures, by virtue of their status, forfeit some of their privacy rights? Finally, are the current legal remedies sufficient to address privacy violations in today's digital age? Thank you for joining us on this journey through the evolving landscape of tort law. Have a look around Dr. Yannis' YouTube channel for more key podcasts on SQE knowledge content.